Hello and welcome to this episode of Too Much Freedom. I'm your host, Roman Balan. Today is November 29, 2014, and we'll be discussing the shooting of Mike Brown. We will discuss some of the evidence and if the prosecutor handled the grand jury properly. Some quick facts about Mike Brown and Daryl Wilson. First off, Mike Brown was 18 years old, he was 6'4" and 292 pounds. He was described as a gentle giant and a student who loomed large and didn't cause trouble. The official cause of death was gunshot wounds to the head and chest. Daryl Wilson was 28 years old. He was 6'4" and 210 pounds, described as an average officer and didn't get into any trouble. He had no disciplinary history, but was part of the Jennings Police Department when it was disbanded due to racial tensions. We know from the grand jury report that blood was found on Wilson's uniform and in his car. There was also shattered glass found in Wilson's car. Wilson's car, my bad. Wilson received what could be best described as minor injuries. Brown received 7 gunshot wounds and 1 re-entry wound. Brown was wounded 3 times in his arm, once in his forehead, once in his head, and once in the chest. Brown's first wound was received in Wilson's patrol car and was in his hand. This is the only wound that was closed and had no gunpowder residue on it. The toxicology report showed that Brown did use marijuana recently, but no other drugs. Due to Brown's height, his head had to be facing downward, with the top of his head facing Wilson, for the gunshot wounds which went through his head and to his forehead to have happened. There are multiple witnesses in the shooting, some supporting Brown and others supporting Wilson. It's important to know that the witnesses are notoriously unreliable because they remember things that didn't happen. They forget things, they don't see things, and they have agendas. Now to the handling of the grand jury. In 1992, the Supreme Court case United States v. Williams, Justice Scalia wrote, "It is the grand jury's function not to inquire upon what foundation of the charge may be denied, or anything to try the suspect's defense, but only to examine upon what foundation the charge is made by the prosecutor." Then Scalia goes on to cite precedent and law. Later, Scalia says, "As a consequence, neither in this country nor in England has the suspect under investigation by the grand jury ever been thought to have a right to testify or to have exculpatory evidence presented. It is the prosecutor's job to get an indictment, not to present all evidence. The evidence suggests that this case should have never went to a grand jury, but the fact remains it did. The prosecutor should have went for an indictment, and the evidence certainly was there for an indictment. We should be going to a trial now, but because the prosecutor had a bias and mishandled this grand jury, we are not." And that's it, folks. Email us at toomuchfreedom at toomuchfreedom@gmail.com. Comment and like. Subscribe to this and tell all your friends and family. Today is November 29th, 2014, and this has been Too Much Freedom.